Hi, welcome back to La Belle Vie. So, an update on the Sarah Boone case. We do finally have her latest letter uploaded to the court docket. So, I'm going to go through it now. I did do a read through. It's quite interesting. She even mentions the decedent, which is the victim. So, all right, let's go ahead. I'm going to pull it up now. Okay, so here we go. As you'll see, it's note that it was hand delivered on 7/21, which was last Friday. Revisions made 7/20. Original not uploaded to date. Second attempt to make public, like everything else in my case, including all my other letters. Freedom of speech, mine. June 29th. I guess that was probably the date she originally sent it. All for your review, critique, judgment, understanding. Try it. Then you'll see it was certified that it was filed in open court. Oh, and here we get a dictionary lesson here. Clarify, to become or make clear. Clarity, clearness, per the Merriam-Webster's dictionary. Where do I even start? Through the officer inmate grapevine and a letter I received from my fan mail. Oh my gosh, who is writing to her? And usually the only way I find out anything regarding my case, since there is no communication from my current attorney, now 10 weeks more of complete silence. Guys, I'm not buying that. That's just my opinion. And yes, my sixth attorney, which I will clarify momentarily. I was made aware my last letter was featured on the news locally, realistically meaning globally. Apparently, my very legitimate, lawful, real reasons and concern I asked and am still caused a stir on top of the already engulfing whirlpool my case has become and made out to look like, which it is not. Guys, sorry, her writing is very hard to read because it's filled with lots of word salad, in my opinion. Hence, my previous questions from said letter. I am trying to protect and maintain my truth, which no one knows, since no one else will, however I can, and keep some of the illicit ugliness at bay, mismanagement at its finest in everything. Why wasn't I included at all? I don't know what she's talking about here. Why wasn't I asked prior to being highlighted so I would know what was said or asked or criticized so I could rightly defend myself? Oh, maybe she's again complaining because she doesn't understand that these are public records. But then she says at the top she wants everything public. What was so newsworthy? By not including me is unfair and adds to the assumptions of what everyone wants me to end up being and thinks I am. This is wrong and also adds to the prejudgment of my case. All of my idiotic theories, empty opinions, false all of the idiotic theories, sorry, apologies, Sarah. All of the idiotic theories, empty opinions, false accusations is all the ignorant world knows from all the pertinent private case details available to everyone except me. Again, Sarah, public record. The defendant in my case. How can I defend myself? I can't, so everything gets meaner, more evil, corrupt, and out of control. I believe this is what a trial is for, right? The world is supposed to learn everything about my case during the trial, right? This is not justice or a system, right? All fairness has been completely removed, right? So, were any of my questions answered? Was anything at all clarified regarding evaluations, amendment violations, case sensitivity protection, suppression? What's suppression? What's the video hit count reached now? My last letter, it was over 3 million. How much does that shareable income make for everyone? Did anyone locate my attorney or discovery? Everything, everything everyone everywhere in the world knows, has seen or listened to, all of my discovery, again, except me. Again, Sarah, the only thing that we know is what's public record. We don't have your attorney files. We have what you make public with these letters you keep writing and whatever is public record. In the meantime, here's a corner piece to my convoluted puzzle. All are wondering when it will finally be put together to see what the real picture is, and also a huge disentanglement of only an inkling of some of the misunderstandings and ignorances swirling about in my case. Before you try wearing my slides, know where they've been. Oh, honey, I don't want to be in your slides. Sorry. God, no. My attorneys, 6. When, as I've said numerous times in my previous letters, why not by choice, I am on my sixth attorney. Here is some clarity so everyone can finally have some understanding why my slides are so worn, but most definitely walkable still. Okay, guys, get ready for some tea she spills on her first lawyer. Oh my gosh. Okay, here we go. Attorney number one, private, February 2020 to May 2022. Well, actually, again, Mr. Padilla was technically her second lawyer. Her first lawyer was the public defender's office that was provided to her when she was arrested and detained in jail. Then a day later, Mr. Padilla, who is a private attorney, was retained. So therefore, the public defender withdrew. So Mr. Padilla is actually attorney, technically number two, but agreed, he is your first real lawyer. So I agree with you on that, is in the sense that he is the first lawyer that did any substantive work on your case. This attorney sold me the world, promised exoneration. I can guarantee, uh, I highly doubt her lawyer promised her exoneration, and supplied an overabundance of other continuous false hopes so I would accept his offer to become my attorney. He had no idea what my case was going to be or was really about. Then he deserted me, his client, naive and new, spelling error, 2 weeks before my first scheduled trial due to irreconcilable differences, meaning I was not persuaded enough to agree with what he wanted me to say or do, and what was not what happened. That's what I was wondering. Remember? Disagreement with strategy. There was no trust. There was no strategy. And if there was, I was never included in on it, or an innumerable amount of other case defining details and questions left unanswered before going to trial. I felt he was sabotaging my case and setting me up for failure due to his micro amount of experience, which I found out after the fact and was not disclosed prior to my acceptance of his representation. I don't think that's the case. Interesting fact, Mr. Padilla was actually one of the lawyers for Sigfredo Garcia of the Dan Markel case, but in any event. Nonetheless, when we did meet to discuss my case and I asked for updates about any progress, he would start talking to me about his client in Colombia, his clown of a sister in law, his nephew going to water parks, trips he's taken, his regrets, where he bought his gold sneakers, and many other unrelated, unimportant, time consuming stories. All the while, I'm trying to figure out what's going on and why he's not answering any of my questions. Nothing was ever completed or accomplished or communicated, building 1,000 fires waiting and needing to be put out before making another to be left ablaze. I was always ignored and in the dark, conjuring the dreadful perpetual question mark looming still over my head. So much I prepared an 8-page packet for Judge Wayne C. Wooten to provide during both court dates, defending myself against my attorney's untrue, unresearched withdrawals. No one asked me nor permitted to speak my truth. To help him out and the court understand my real concerns, along with all the carryover since day one. I was trying to avoid going through any of this again going forward. It had already been 2.3 years. I wanted the judge to include me and know I have a side also in everything. Plus, I knew Judge Wooten would be appointing my next attorney in hopes he would listen and appoint a more suitable, experienced one accordingly to save time for everyone to progressively move forward. He must have been throwing darts at a dartboard, blindfolded. Is he saying that Judge Wooten just. Okay. This attorney number one is untrustworthy, unreliable, unprofessional, with poor leadership skills, and is extremely unorganized. Okay. He was unable to perform ethically, and as an adult, ignoring his client, misleading and deceiving. He didn't even respect me enough to speak with me before his withdrawal to try and remedy or figure anything out to stop. I was totally blindsided. Because of the magnitude of his ineptness and dereliction of duty as a result, withdrawing from my case at the 11th hour after taking over 2 years with nothing I knew of but disappointment, I could have reported him to the Florida bar for legal malpractice. Exhaustion 1. I'm also still waiting on him to release all of my case files and documents obtained and accrued during his representation, including well over 100 pages of my handwritten notes and information, which is irreplaceable. He is still not helping. Him no longer being my attorney was not my choice. Okay. And I said before, I mean, we obviously don't know what the communication was between these two, but as I mentioned, you can tell from the docket that there was quite a bit of work going on. And as I mentioned in my video yesterday, maybe even possibly to the point where an expert psychologist might have even already have evaluated her, at least if that my reading of the JAC opposition brief is correct. Okay, so attorney 2, 3, and 4. Public defenders appointed by Judge Court, May 2022 to June 2022. Judge Wayne C. Wooten and the court repeatedly appointed me public defenders 3 without any research or care. And after I continuously explained to each and tried to the judge court, they could not represent me to their representations of the decedent. I mean, I can't even believe she's referencing George, the person she loved. Now she's calling him the decedent. We've done our homework. I was told. I received 3 withdrawals, none by choice, definitely not systematic. And again, I've done a video on this. They had to withdraw due to conflicts of interests. It's against conflicts laws, Sarah, for those people to have represented you. Attorney number 5, conflict, appointed by Judge Court June 2022 to July 2022. Upon our first and only meeting, this attorney expressed his mass confusion in why he was appointed by Judge Wooten as he was leaving for a teaching job out of Orlando within the week. Okay. I learned more from this attorney in one meeting regarding my case than all prior combined. It was extremely disheartening he could not continue representation and set the bar going forward, especially regarding honesty and respect. I received only 2 letters from him, one introduction, one withdrawal. He also did not know where any of my discovery was or notes, now 5 attorneys later, not by choice. I mean, I can't imagine that much was done in those conversations if he didn't even have the trial. He didn't do any work on the case. He had to withdraw because he was taking a teaching position, it looks like. Okay. Attorney 6, conflict. Appointed by Judge Court July 2022 to present. 1 year mark, 7/11/23, 12 months, 365 days, 52 weeks, summarized. 8 total months, 240 days and counting. Are with absolutely no communication in any form, completely inactive. I mean, I don't know, that might be the case. We can't It's hard for us to tell what work has been done. Total amount of hours as court appointed attorney, over 8,760. Total time spent with client, me, 6. Total hours spent with client, 7. Total phone numbers given to client from attorney, 2. Numbers that work, 0. Total time speaking to client via phone, 0. Total number 15-minute video visits with client, 4. Total number of letters sent to attorney trying to communicate, 8. Total number of letters to the judge trying to communicate my unsuccessful communication with my attorney in hopes he will communicate with him to communicate with me, 7. Letter to other parties to communicate, 3. She must be writing to people. Total times in court, 3. 1 was an attempted withdrawal. That's true. Remember, he did try to get out of the case in December. The judge was like, no, you're not getting out of this case. 2 carry over and over. The last time I saw my attorney, May 18, 2023. Okay. Where is the progress after 1 entire complete year? Unknown. Everyone, please look at the Orange County, Florida Clerk of Court's website and see for yourself. Yeah, I've read the entire docket. Am I looking at it wrong? Reading the contents incorrectly? The mass majority of work seems to be from my correspondence. Well, Sarah, you've written a lot of letters, but that is not what the docket is full of. But in any event, if not my letters, there's minutes, some live, to view from non progressive lackluster court dates stating the same information and some continuances, and of course, none of my comments, questions, concerns, or questions from any. I don't just sit there, edited like my case. So she trying to allege that people are like taking stuff from her case? I feel it important also to communicate to everyone so you understand the undertaking it is for an inmate to attend court and why it is so important to me to have progress, to report to make the day count. Oh, we're getting some information on her life. We are woken up at 3 a.m., taken to a holding cell and wait plus 4 hours, then taken to the courthouse and put in another holding cell for however many hours until court time for only a 5 to 10 minute opportunity in front of the judge to say anything, if at all. That's kind of how that's how the system works. You don't just get to have meetings with the judge. Then taken to another holding cell for however long, transported back to another holding cell, wait however long, then taken to another holding cell, then back to our dorm. Most court dates are court days, spending between 8 to 14 hours for little to no time to speak. It's important to meet us. We matter. Hence my letters. What will be said for this one, I wonder? She doesn't. Like Lois looking to the skies for Superman? Sorry. I'm hoping, praying for an attorney to step up and truly represent me with honesty, intensity, understanding, respect, and perspective. When they introduce themselves, they can me also, the real me, properly, not the Frankenstein monster I'm being so wrongfully and incorrectly pieced together as from all the propagandized. There's nothing propagandized about this. Everything people see is your letters and the the court evidence that we have so far, which is just the interrogation and the interviews on site. But anyway, okay, sorry. Okay, let's start over. I'm being so wrongfully and incorrectly pieced together as from all the propagandized, lucrative defamation. I don't know what you just said about your first lawyer there. And attempted destruction of my character and still intact integrity. Clearly, also, everyone can see all of the aforementioned information regarding my attorneys was not ever a strategy of mine, nor will be. Is it a strategy of the judge in court? I don't know. Judge Wooten. Oh, here's a special note to Judge Wooten. Judge Wooten, will I be included, please, in my upcoming status hearing prior to my PTC, pre-talk conference, which is also the 1 year mark of attorney number 6 on 7/11/2023? Will I be permitted? I was not. Attendance from you, like all the news channels and professional YouTubers. I hope I finally see my attorney, whom will, I'm sure, tell me, as you so graciously explained to me in my last pretrial conference I was made a part of, consuming my minutes of your invaluable time, that you and he have other clients. I am a client and have been for over a year with this attorney and paid tax dollars to utilize all of my available resources, including and not limited to a state or government attorney appointed by the court. And you will always have clients. You never know when you may become one yourself. Please do not discredit my truth. I am who, not what. Respectful and diligent, Sarah Boone. So, guys, what did you think? I first did not like her referencing George as decedent. I mean, this was supposedly someone she loved. I mean, she told him, "Don't wear that's my name, don't wear it out." Well, why can't she call him by his name? I mean, I just that bothered me. Sorry. And the information about her first lawyer, wow. I mean, I don't know. What do you guys think? I mean, of course, Sarah is all defendants are innocent until proven guilty, but these letters are very interesting insight into what type of defendant she is, and what type of defendant she may be to work with. So, what do you guys think? Anyway, never a dull moment. As I said, the next progress in this case will be the September hearing with the JAC regarding the cost issue for um, her request for a new um, forensic psychologist. So we'll see where that goes. In the meantime, thanks so much for joining, and I hope to see you in my next one. Bye.